Dear participants, I will shift to English in order to present our organization and to present our today's speaker. First of all, I would like to say that my name is Roman. I'm a project manager of Center for Civil Liberties. It's a Kyiv-based think tank, and today my organization holding an educational event for you. For us, it is not our first webinar. Internet freedom domain. Sorry. Yeah. Internet Freedom Project started this summer, and today it's our fourth webinar. The project itself entails various activities, including educational one, and we plan to hold overall 10 lectures. And our aim is to balance between Ukrainian and international scholars. That's why today our lecture will be in English and will be delivered by international legal professional. Also, the recording of our previous webinar available online on our YouTube channel. After the event, I will send to you a feedback form and the link to our previous educational materials or video recordings if you like to enhance your knowledge in internet freedom domain in ICT and IP law. This event is also recorded. If you have a question to a speaker, you are invited to text them in to our chat and to write them under, for example, Facebook translation if it's easier for you. Our today's event is conducted on CCL platform, Kyiv School of Human Rights and Democracy. If you are new to this platform, I will briefly present it. It is an educational online learning platform created and hosted by Center for Civil Liberties. We regularly organize summer schools, hold lectures, film screening, roundtable talks, and other more curricular courses. This school is a great opportunity for citizens to get basic human rights training and get involved in human rights activism as a volunteers. And for instance, our today's lecture will help you to protect your rights from unlawful practices of data collection. And our today's lecturer is Mr. Еюп Кун. He is a graduate from Istanbul University, and he also holds a master's degree from London School of Economics and Political Science. His previous educational and work experience are in domain of informational technology, media, and communication law. Last year, he also worked for data protection unit at Council of Europe. Finally, he is also an advocate who is admitted to Istanbul Bar Association. Today, he will present a lecture on impact of the use of facial recognition technologies on fundamental rights, beyond right to privacy. And finally, I will mention that overall, our events under Internet Freedom Club are conducted with the support of ABAROLI. ABAROLI is American Bar Association Rule of Law Initiative. From now on, my part is finished, and I'm glad to invite Mr. Kun to give his presentation and share PowerPoint. Thank you, everybody. Eюп, the floor is yours.
Thank you, Roman. Can you hear me and can you see my screen clearly?
Yes, I can. We can.
Okay. So now I will start my presentation. So hello, everyone. Thank you for this kind invitation, Roman. Today I will present my current findings about the impact of the use of facial recognition technologies on fundamental. Or is there any other fundamental rights that must I'm a doctoral researcher at KU Leuven Center for IT and IP Law. Briefly describe what is facial recognition technology, so we can have a common understanding of FRT technologies and how they can have an impact on our fundamental rights. Facial recognition is a technique of identifying or recognizing a person by using cameras. Then these softwares create biometric templates, and then the system and the software will evaluate the degree of similarity between two facial templates in order to find a match. I would like to shortly give the current classification of the FRT technologies with respect to their purposes. And one of the purpose would be like verification. The second one is identification. And for verification purposes, I can just give the example of facial ID and facial ID technologies that you use for opening your smartphones. And because these technologies are used for verification, and the another is like one-to-many for identification purposes. There is one database, and from this database, you process all images that you find, then you try to match. And this classification is quite important because when it comes to purpose of verification, there is for this purpose, FRT technology or the users of FRT technologies provide further information about it, and the individuals have more control over the use of these technologies, because you opt in the smartphones to use it, and it is generally more acceptable when it comes to this fundamental rights implications. But for identification purposes, as it's basically creates a surveillance regime, it has further implementation implications, and we will discuss further. And I would like to give some the practical examples of use of FRTs. Generally, it is used for preventing crime and find suspects on the watch lists of like terrorists or like some criminal suspects. And also it can be used for finding missing persons like children that in the public spaces, or commercial companies that can use these technologies to recognize VIPs at events, so they can treat their VIP customers more favorably, and they can easily identify them in the events. Then fourthly, the schools can use to prevent threats, and it's also recently used by schools for tracking school attendance. And there is like one specific case about it in Sweden, and Swedish Data Protection Authority found it unlawful, and maybe I will discuss further about this. And also these technologies can be used for the access control to sensitive areas. And the last one is also related to more verification rather than identification purposes. And I would like to now specifically describe and give further information about live facial recognition technologies, because live facial recognition technology is maybe the most dangerous type of FRTs, so to speak, because it's directed towards everyone in a particular area, and it captured the biometric data of all individuals passing within the range of camera automatically and indiscriminately, and the data processed in real time and potentially on a mass scale, because these technologies are used in public spaces, and it targets the people on a mass scale. And when you go through these public spaces, then your data will be processed and individuals will not have any control over the processing of their data through these facial recognition technologies. And when it comes to why facial recognition technology is so unique, the human face is quite important, and it is important for communication and social interaction. And also, according to a recent study, it is the most reliable proxy for identification of human beings. And thirdly, there is a low transaction cost for extracting diverse forms of information from faces when you compare with other biometric data like fingerprints. And when it comes to the potential harms of the use of facial recognition technologies, it will have a disproportionate impact on people of color and other minorities and vulnerable populations. And I will give further information in the next slide. And secondly, it gives like a power for governments to arbitrarily tracking people's movements everywhere. And then it can also normalize the elimination of practical obscurity. And I will briefly discuss these terms in the next slides. And it will provide further amplification of surveillance capitalism. And also this concept is quite popular in data like economy-based, data-based economy area. And it would increase the use of surveillance, the use of FRTs can amplify this surveillance capitalism, because all the time your data is processed through these softwares, then they can supply some personalized products to you, or they can have like advertisements directed to your personality. And then also fourthly, it creates security vulnerabilities. And when you use new type of technologies, then also the cybersecurity of these technologies quite important, and it causes more and further risks, because fake this data and then you let's talk about the impact of imperfect facial recognition technologies. Everyone is not technologies is that there is like a low accuracy level of these identification. And especially for people of color or other minorities, the accuracy rate is quite low when you compare with accuracy rate with white people or with other people. And then let's assume, I would like to give an example of this. Let's assume that, and also most of the facial recognition technology service providers provides more than 99% in almost all contexts. And in Apple's Face ID system, and when you see this false positive rate, you can think that, oh, it's quite perfect. So, why we should not use them? It will be good and acceptable for further implications and results of the false identification in criminal prosecution, or you just machine misidentified you, and it's compared, with terrorist suspects, then they harm or acceptable in these context of imperfect facial recognition technologies. I mean, when you have accurate and perfect facial recognition technologies, it will mean that we purpose that we pursue, but the problem with facial recognition technology is not limited about the accuracy rate, but also there is a potential harms associated with perfect, quote unquote, perfect facial recognition technologies. And I think these four approaches are quite important when we rights. The first one is, it is generally considered chilling effect doctrine. And this concept is generally used in surveillance, in general surveillance technologies. But for facial recognition technology, I think it creates more risks because you feel that you are being monitored all the time in public spaces. And it would result in absence of the behavior. Chilling the effect doctrine in that sense means people and individuals, as they are being monitored and they feel that they are being monitored all the time, they can censor their expressions, their behaviors, and it would impact on people's own freedom of expression or their freedom of personality as well. Because as they feel that they're being monitored all the time, they can censor their behaviors, maybe without any thinking. And it will have the use of facial recognition technologies, especially in public spaces, might have this impact, and it must be considered duly in these times when we decide on whether FRT technologies can be used widespreadly or not. And additionally, the chilling effect doctrine has another aspect as well. Even people maybe, because there is some arguments from the governments that, empirically, there is no evidence about the self-censorship. We asked some people about, if there is a facial recognition technology, whether you will change your behavior or you will avoid expressing yourself, but it's still a danger, and I think the empirical research will not give the correct response and correct answer to it. And when it comes to another aspect of chilling effect doctrine, also when people believe that they are being monitored all the time in public spaces, or there is a chance of being monitored all the time, they will have more tendency to act incompatible with social group norms. So they even, maybe they will not abstain from behaving in a specific way, which means self-censorship, but they can act incompatible with social group norms. So they will act how society perceive the act in that specific circumstances. And it will have an impact on the self-fulfillment of the individuals in public spaces. And secondly, it would erode the normative ideal like freedom of the will, because when people feel that they are being monitored all the time, it will reduce people's incentive to think about how they should act and who they should be, because it's also quite close and related to shaping the behavior issue. People will act because they will act in accordance with law, because not because of the fact that it is ethical to behave in that way, but because of the fact that they are being monitored and they will be punished. So it will have a chance to reduce people's incentive to think about how they should act and who they should be. And thirdly, the loss of control about our body, because when you can keep control over your data, or yourself, your body has, because when facial recognition technologies are used, they will have further, because your face images has some mathematical hash value and you can't recognize it, but machine can do it. And then they will give further functions to these hash values, like identifying you or verifying you. And it will have an impact on how you perceive your body and how you lose your control over your body or over your face. And fourthly, the loss of obscurity is another issue. And also it's quite important, because obscurity means you have a means to, you have discretion to choose the disclosure about information and communicate different aspects of your identity in different circumstances. You don't want to disclose every information about you, and you want to obscure yourself, and and it's closely related to anonymity as well. So you feel that you are not recognized all the time in public spaces, but when like perfect facial recognition technologies are used everywhere, especially in public spaces, you will lose this kind of obscurity, which is quite important for development of your personality. And now I will discuss, these discussions are related to like ethical discussions. And I think even they have like ethical background, it doesn't mean, also the fundamental rights is quite closely connected to ethical problems. And these are not free. The right to privacy and data protection has the value themselves to protect people from these uses. But first, before delving into the privacy, I would like to discuss the general misconceptualization of privacy. These arguments you can hear everywhere. As long as you are in public, people can already see you. So when people see you, why facial recognition technology don't see you or don't use your data? And you don't have privacy in accessible spaces. That people don't fear surveillance as a privacy threat because they have nothing to hide. And some also may argue that we reduced privacy to secrecy and assume that only things that are confidential worthy of protection. But when I briefly discussed the right to privacy under European Courts of Human Rights case law, the primary goal of Article 8, which covers right to privacy, is to guarantee the development and fulfillment of personality. And even the court talks about the right to personality and right to personal development. And independent life choices require the free and unobserved development of own abilities. I will just come here. I allocated more than 7 or 8 minutes to this part because these are these harms quite related to our personal development, and we should have some space free from being monitored. And right to privacy under the case law is quite corresponding to these needs and to prevent these harms. And now I will briefly talk about how data protection framework can provide appropriate, it has appropriate safeguards for the use of FRT technologies. FRT technologies, it's about the processing of special categories of personal data, because as I mentioned briefly in my first slides, facial recognition technologies uses biometric templates. And these biometric templates is intended to uniquely identify you from others. So it is like a biometric data, and biometric data is special categories of personal data under Convention 1A+ and the Council of Europe, and also General Data Protection Regulation. And for this reason, the use of these technologies will fall within the scope of data protection framework. And when we, I don't want to discuss every steps or every aspects of data protection law, but if of course, if you have any further question, I can, explain further about this. Lawfulness, these are the general principles of data processing. And when you process personal data through facial recognition technologies, you have to comply with these principles. These principles are lawfulness, so you have to have like a legal ground for processing personal data. It might be consent, but also substantial public interest, or sometimes legitimate interest of companies will be enough. But as I said, generally also the consent requirement is so high, and we will discuss further. And also purpose limitation, your purpose of processing will correspond, the purpose will correspond to data that you used, and also data minimization, accuracy, and accountability. Accountability is also quite vital in FRT technologies, because you have to prove everything that you are doing, and also you should give evidence how you carry out your obligations during the use of facial recognition technologies. So, I would like to briefly discuss these aspects of data protection law. For special categories of personal data under the GDPR and under Convention 1A+, it is, as a rule, it is prohibited to process the special categories of personal data. But then there are some exceptions. And one of the exceptions is the consent. But the consent must be highly qualified. It means it should be explicit, affirmative, and informed. So like data controllers should really fully inform you before getting your consent. And for also there are, as I said, there are other grounds for processing of personal data, but as there are exceptions, they have to be interpreted narrowly. And so it, for especially whether the use of FRT technologies are lawful or not, depends on this discussion. And most of the uses will be unlawful because they will not, meet these requirements. But of course, it requires case-by-case analysis. And data protection framework also provide transparency. So data controllers shall provide the information to data subjects and make the processing transparent. And also data subject rights can have a role in that aspects, especially right not to be subject to automated decision-making. If police officers use FRT technologies to find and to identify some aspects, they have to have human in loop. It means that there should be like humans intervention in the decision-making process. They shall not rely on the similarity rate that is given by FRT technologies. And it is quite important from data protection perspective. Fourthly, data protection impact assessment, I think, provides very strong procedural safeguards, because according to the GDPR, Article 35, the data controllers, if the data processing is highly risky, and since the facial recognition technologies in public space is considered risky data processing, they have to evaluate the risks to the fundamental rights before deploying these technologies. And when I look at the Data Protection Authority case law and also the case law in the United Kingdom, we can clearly see that data protection authorities or courts see it. They just used impact assessment, and they said, data controllers didn't properly analyze the impact of these technologies on fundamental rights, and they find unlawful the use of these technologies in public spaces. But there are some arguments against the data protection framework, and they said, data protection framework generally needs like trigger from data subjects or from supervisory authorities, and generally the remedies are quite tailored for data subjects. And we can see in a recent complaint in Hamburg about this. Clearview AI is like an AI company, and it's like a facial recognition company, and it collected facial images from the internet and extract the biometric templates from this. And some data subjects complained about the use of the processing of their personal data, and they said, you should delete. They used the right of erasure, and they said you should delete the mathematical hash value of the person, mathematical hash value of our facial images. But the Data Protection Authority only, ordered for the deletion of this specific person's data. And also, I want to just give provide a further, developments in the EU about facial recognition technology. There is like a prohibition on the real-time remote biometric identification system in publicly accessible spaces for the purpose of law enforcement is prohibited. So, the AI proposal use more like technology neutral language. They use real time. So, it's quite correspond to the live facial recognition technologies in my presentation. And they said it is prohibited unless and as far as such use is strictly necessary for one of the following objectives. And they provided some elements and how they can use for these specific reasons. And then they provided some safeguards for the use of FRT, and it shall be subject to a prior authorization by judicial or independent authority. There must be a balancing of interest for the use of FRT in specific deployment, and there must be some temporal, like timely, geographical and personal limitations for the deployment of FRTs. And there are many, generally, in the EU, as this prohibition is only related to prohibition on the use of facial recognition technologies by law enforcement authorities. The rest of the use of facial recognition technologies is only subject to data protection law. Even data protection law provides some safeguards. Generally data protection scholars calls for like a ban on surveillance regime and use of FRTs in public spaces by both public and private actors. So thank you for listening to me. I hope I didn't exceed my time. If you have further questions, I'm very happy to answer them.
Eюp, thank you for your expertise. Now you can close your PowerPoint presentation. And I would like to invite participants to ask tete-a-tete questions, participants who currently log into Zoom session. And maybe while you are preparing, I have some questions received from the chat, and I would like to ask them directly now. You already covered some aspects of these questions, but maybe for the sake of clarity and maybe for the sake of repetition, I will still address some. For example, Eюп, what is the relationship between digital rights and national state security, and how to balance these relationships?
Yeah, generally, especially live facial recognition technologies, generally for facial recognition technologies, like states try to, balance and try to justify their positions by referring to national security, because, national security is also quite important for everyone living, in a country, because if there's like a terrorist threat, an attack in a public space, and if the use of FRTs can have a benefit and can contribute to the prevention of this attack, it of course might be used. But I think generally governments, excessively use these arguments to, prevent and to restrict fundamental rights, and especially, as I said, of course, the national security is important, but the delineation and the limitation and delineation of the scope of national security is quite important. And the use of FRTs must not be, it must not be used as a rule because of the proportionality requirements under the case law or under the human rights in general. So, of course, it has an impact on our digital rights. But as I said, it will not result in use of FRT technologies to create like surveillance regime in public spaces. I think the argument about like loss of obscurity and like the chilling effect doctrine is quite important to guide the policymakers in that area. And I think the solution is all the time, as we are lawyers as well, the proportionality and the context-specific use of these technologies. And it is not so clear, whether these technologies have like, outweighing benefits.
Okay, thank you. And I have a question related to your answer. So, what can we do right now? What are the instruments to tackle potential misuse of facial recognition technology in law enforcement activities, for example? So what can be done today? You mentioned that citizens should pressure the parliaments to have more control over the situation, not to be in hands of only enforcement organizations. But what else?
I think, the only tool that we have in Europe, at least, like the data protection framework and fundamental rights protection, I think the NGOs has role in civil society or individuals. The good thing about data protection law is that, we can use these rights as an individual, and we can have an impact on these users, because it will create a pressure against the governments if they use these technologies. Because when you like revoke these arguments in the court, then even if it is like maybe it's like an individual case, it can create like further implications and further awareness of the public. Because maybe these technologies are used for several years or maybe several decades, but especially after the data protection law entered the force, and people start to become more aware of these rights, and then they start to use it. And I think in the absence of like a moratorium or like a prohibition, absolute prohibition on the use of these technologies, data protection law have some means, and data protection authorities are quite well equipped, have like expertise in reacting that. I saw, in like France, in Sweden, in other European countries, data protection authorities use their powers and enforcement powers to, prevent the use of these technologies by law enforcement authorities.
Okay, thank you. Maybe another one. Should facial recognition technology should have additional safeguards because it's used at demonstrations and other mass events? And it is a good question because in Ukraine, as in other part of the world, sometimes police or secret services monitor people movement via following their phones, take unlawfully video footage, and then use it in court to bring person to some sentence. So it is a very good question for contemporary modern Ukrainian society. Mm-hmm. Eюп, what is your scope? Additional safeguards for FTP?
I think especially, as I said, data protection impact assessment. I'm not very good at like data protection law in Ukraine now, but this impact assessment, is created under the GDPR, not the Data Protection Directive, but and also under the Law Enforcement Directive. When like law enforcement authorities decided to use these technologies, first of all, there should be like ex-ante control mechanism, and there should be need for like judicial decision to use these technologies. But in addition to these ex-ante monitoring, the impact assessment, I think, also provides very important safeguards. Because when it comes to like events of, the mass events or demonstrations, the police officers shall try to justify why and how it is necessary to use these technologies, or how they use these technologies, because especially when it is used in demonstrations, it will has a harmful impact on people's behavior. People will have more tendency to censor themselves because of, they are captured by these cameras. And I think, the freedom of expression is, must be considered by law enforcement authorities. Maybe thirdly, as if the use of these technologies are unlawful, the evidence that is obtained through these technologies, might be unlawful as well. So they can't be used as a basis for convicting people for whatever the crime that they, mention, or they just try to use it. I can't hear you.
Sorry. We have a question from a Zoom chat, and I will read it aloud to the audience. How do you think? Is it possible to establish a single European Union identification system and its regulation?
Actually, I think it will be hard to, establish a single EU identification system. And I don't understand, what is the meaning of identification system? It's about like, you mean like identity system or facial recognition identification system? Because now there is new current developments about, electronic identity systems around Europe. But it is not, part of my expertise until now. I didn't delve into these questions in my research, so I'm not very,
Yeah,
well equipped to answer this question.
I may send people to check, for example, European Union Interpol system of fighting crime. We are using and exchanging data, including data obtained via face recognition technology, but is a very narrow domain of international prosecution. Otherwise, we can also speak about European Union external borders and biometric data collected from the third nationals entering European Union. Also, a big debate is rising in recent decade because of terroristic attack conducted in Paris, Charlie Hebdo case. So it is a working process, and there is voices for and against any kind of single European Union facial recognition technology identification system. But technically, it is not yet at place, and there is a big question about human rights risk. So in nearest future, we will see, but currently it is still debated, and it is very costly activity to budget it from European Union funds. But in connection to this question, we also have a question, what is the legal basis for facial recognition in European Union now?
You know, generally, there is no specific framework that police officers can use. And also it was a discussion point in the United Kingdom. And they said, because there are some, general authorities that is given by law to police enforcement authorities to prevent crime. And they, rely on these, general basis when they try to, legitimize and, justify their use of facial recognition technologies. But like a recent case law in the United Kingdom, when also, it's also quite related to European Union law in that occasion, they said, the use of FRT technologies, live facial recognition technologies, is unlawful because it is not, the use is not provided by law. So also, for instance, in Sweden case, as I mentioned before, they, like the school, like private, public school, primary school, try to use, they test the FRT technologies for attendance, and they said that, we don't need consent because according to some law in Sweden, we should track people's attendance. So they said that, according to a law about, primary schools, there's a one provision about, people's, we have obligation to track people's attendance. But then the DPA said that, this provision is quite vague. And when it comes to use of FRT technologies for these kind of uses, you should have further restrictions and safeguards provided by law to have this authority. And they said because of that, you can't rely on like national law for use of these technologies at all. So generally, the discussions, what is the legal basis? Is there any legal basis to use it? Of course, it depends on the national jurisdictions and how it is interpreted. But if you want to use this kind of technology, which has further impacts on fundamental rights, it will be more specific rather than vague. This is one of the common points that I think it's agreed by scholars and courts.
Okay, and the last question that I receive is, what are the most human rights friendly countries regarding FRT, and what are countries that are usually violating human rights in this particular domain?
I think, we can't say, some countries are more friendly and non-friendly, because it's about also transparency. Maybe some countries use these technologies, but people don't know about it. There's no cases against it. For instance, in the UK, there are many cases, and one High Court case about facial recognition technology, and High Court said that it is unlawful to use it, but it doesn't mean that FRT technology is used only by UK or UK government, is unfriendly or friendly. I think also the transparency and how NGOs, civil societies, or individuals respond to use of the technologies matters. So I think we can't classify, the countries about friendly and unfriendly when it comes to use of FRTs, because these statistics about this would be quite wrong.
Thank you for your answers. Dear participants, if you have last-minute immediate questions, you are able to ask them directly or to text in the chat. We still have some time. Also, Eюп, I would like to ask, our participant would like to have your PowerPoint presentation. And if you willing to share it, please send to me it after the presentation, and I will inform our participants. But I will also say that if you cite presentation, always give a link that it is originated from Еюп Кун public lecture. Always give the quotation mark for your source. Also, I hope that it is okay that afterwards I will send a feedback form for a registered participant. It is extremely important for us to know your opinion about the topic of the seminar, whether your question was spoken out, how you feel overall with the program. So don't hesitate to take 1 minute feedback form to fulfill the form. I will be personally very happy. And I will check the chat. Yeah, we don't have any questions now. And so it is my pleasure to say thank you for Mr. Eюп and his presentation. It was a pleasure to have you on board on our team. And for now, our presentation is over. Thank you everybody for participation, for your question, and let's stay in chat. Thank you.
Thank you, Roman, for this invitation, and it was a pleasure for me to speak to our Ukrainian friends about the use of facial recognition technologies.
Good luck, everybody, and good evening. Bye.